This podcast episode reflects the opinions of the hosts and guests and not of Greenberg Traurig LLP. This episode is presented for informational purposes only, and it is not intended to be construed or used as general legal advice nor a solicitation of any type.
A problem here is that, you and I are tax experts. I'm sure a lot of the people listening spend a lot of time thinking about tax. The Supreme Court is not.
Yeah.
Don't get me wrong, they're all very smart people.
Hello, and welcome to Gettin' Salty, a state and local tax policy podcast hosted by Greenberg Traurig. My name is Nikki Dobay, shareholder in the Sacramento, California, and Portland, Oregon offices. Today, I'm very pleased to be joined by a very good friend, Joe Bishop Henchman. Joe is the executive vice president at the National Taxpayers Union. And Joe, thank you so much for joining me for the podcast. And can you let our listeners know what the National Taxpayers Union Foundation does, otherwise known as NTUF?
Sure. Thank you, Nikki. National Taxpayers Union has been around for over 50 years, and our mission's a simple one. We want to make sure the taxpayers are represented at all levels of government. So in Congress, when they're debating stuff behind closed doors, in state legislatures, in regulatory agencies, and in the judiciary through amicus briefs and direct litigation. We want to make sure that the taxpayers are being heard and the long-term fiscal future is not neglected. So that's what we do.
Well, and you all on the direct litigation engagement front, that's just been a really great thing to see. I know you're often working pro bono with taxpayers and really pushing cases that may not get pushed because there's not enough money at issue or taxpayers don't have the resources to push those issues. So I just think it's really great work you're doing, and happy to see that space getting filled.
Yeah, and happy that we get to work together on some of those. And there are so many cases that could make good law, but for whatever reason, the plaintiff, the company doesn't want to go all the way on it, and that's understandable given all the competing pressures there are. So we go out there and we try to find clients that are willing to go to the distance and result in better law for all taxpayers.
Well, keep up the good work on that front. Today, you and I are going to be really focused in on a specific issue, the Moore v. United States case, which is currently up at the Supreme Court. So we're going to talk about that. But as a new guest to the show, I have to ask you the big question. How did you get into state and local tax, Joe?
By accident. No, I didn't grow up wanting to be a tax attorney. I've always been interested in policy and fiscal issues. So when I first came to Washington, I actually did some policy analysis of the transportation bill. This was in 2004. I think it's the last time we passed a transportation bill. When I was in law school, I went to law school at GW. There were looking for, I was looking for a job for the fall.
Mm-hmm.
And a think tank called the Tax Foundation was looking for a law clerk to help with amicus filings. And so I ended up getting hired in that role. And the fall clerkship got extended to a spring clerkship and got extended to a third-year clerkship and a summer. And then they ended up bringing me on. And that's a place where you learn all about tax. And so that's how I ended up in it, and get to continue following it. And what I tell people is I get to pretend to be a constitutional lawyer because so many of our issues deal with the Due Process Clause and the Commerce Clause and other federal and state constitutional provisions. So it's almost a misnomer to say a tax lawyer, but that I get to tell people that.
Well, you're in very good company because I think so far there's only two guests who have said they've wanted to be a tax lawyer since they were a very young child. So most of us stumbled into this. And I would not say that you are pretending to be a constitutional lawyer. I think what we do often is actually do constitutional law, and which is a great segue into our discussion of Moore, because This is a constitutional case, but comes at it from a very different angle, I would say, since we're not dealing with our general provisions that we so often get into, due process and commerce. So, um, for just start to set the stage, and please jump in with additional facts or background on this. But so Moore is not a state tax case. This is a case that really involves whether or not IRC 965, or the transition tax that was put in place by the TCJA, violates the apportionment clause of the U.S. Constitution. And so we've got two constitutional provisions here: the 16th Amendment, which is the amendment that authorized the federal government to impose income taxes. And here, what the taxpayers are saying, or Moore is saying, is that the 16th Amendment does not cover this tax. Thus, it is required to comply with the apportionment clause of the Constitution, which is in Article 1. So, Joe, why does NTUF care about this case? Why do we care about this case, as state tax lawyers? So,
Yeah.
thoughts on that?
Well, you can come at it in a lot of different ways, and I mean, you framed the case well. That's literally what the case is about, but of course, it affects more than just the issue in front of the court, and that's why everybody's kind of interested in this case. And there have been already, I think, something like 30 briefs filed by outside groups in the case. I imagine there'll be more being filed, and there's already a lot of ink being spilled,
Mm-hmm.
not just in the trade press, but it's starting to leak out into the kind of the regular world press that this case may be a big deal. So, like, you framed it as one angle. Another angle is this lawsuit is attempting to declare the Tax Cuts and Jobs Act unconstitutional. Now,
Mm-hmm.
they just want to declare one piece of it unconstitutional for this one taxpayer. But anybody who's ever dealt with courts knows that you can't make judges do what they don't want to do. And just because the plaintiff doesn't want, only wants to have it declared unconstitutional in this one instance for this one provision, doesn't necessarily mean that's what the final outcome will be when the Supreme Court hands down its decision. And so this is a big deal because the TCJA does not have a severability clause.
Mm-hmm.
So unless you convince the Supreme Court to create one, which I guess they've done in some cases, but they're not very happy when they have to do that. This could potentially unravel the tax code that we know and love since 2017, and all the provisions associated with it. So that's one angle. Another angle is, I think it's a big reason why a lot of people have filed briefs in this case, is they think this is going to be the wealth tax case.
Yes.
Now, why is this the wealth tax case? This doesn't actually involve a wealth tax. This involves the transition tax. The Ninth Circuit, in ruling for the government and against the
Mm-hmm.
Moors, they didn't just say, "Oh, this tax is constitutional." They basically said, "Well, kind of any kind of tax would be constitutional if the
Right.
federal government wanted to enact it." So there's a big worry from people that unless this is reversed, um, a wealth tax is on the table. So you see that on a lot of the briefs, including in our brief, I'll add. And then a third angle, why does it matter for the states? Well, revenue just doesn't go to the federal government. There are a couple
Mm-hmm.
states that piggyback completely on
Right.
65. There wasn't a lot of them, but a couple of them did. But certainly a lot of them have benefited from the increased revenue that has happened, that has flowed through to the state level in the last couple of years after the passage of TCJA. And I would imagine a unraveling of the entire Tax Cuts and Jobs Act would be noticed at the state level, and certainly at the company level too.
Well, and to your point about the TCJA having no severability clause, this even goes further than that. If the court were to rule completely in favor of the taxpayers in this situation, it would have far broader reach than just those provisions. Because and really, maybe we get into a little bit about the realization piece of this, or unrealized income. So
Yeah.
the 965 is was the mechanism that was used to move our system from a worldwide, at the federal level, worldwide system to a territorial system. And to kind of make that transition, we had to figure out what to do with all this deferred income. And so that's 965. And there was this deemed repatriation that tax was applied to. They provided a favorable rate to kind of make that pill a little easier to swallow, since it went back, it was going back 30 years. And so really the crux of this is that was a deemed income event. So there was no realization of actual income. Now, sometimes there were for certain taxpayers, but
Yeah.
under these
You,
facts, as I
you could
understand
have,
them,
if you wanted to, have liquidated your overseas
correct.
asset,
Yeah,
but you did not have to,
right.
under the way they did it.
Right. So there's no actual realized income. This is all unrealized income. And so the Moore's argument is that violates the 16th Amendment, is thus subject to the apportionment clause, and fails in its current state on that side. So if the court were to say, the Moores are right, and you have to have an actual realization event, which seems to be, there's some cash that's changing hands. Somebody's, actually getting dollars in their hands. It's a lot of sections of the code. I mean, the song that's running through my mind currently is "It's the End of the IRC as We Know It," which would be done by the very cool state and local cover band covering the REM songs, but it very, very drastic impact.
Yeah, and you
If
see this in some of the briefs, especially by some of the academics, and they just kind of go through all the provisions where we don't have strict realization as you
mm-hmm,
might think of it. So mark to market provisions,
mm-hmm,
um, 401k in some instances, you end up deferring tax or paying tax early when there's not a realization happening. And you talk about going back in time and unraveling big pieces. Subpart F itself
mm-hmm,
might fall under this. So I think the taxpayers got the message because in their latest brief they tried to talk about how uh, what they want will not unravel all of that other stuff. It
right.
will just be limited to what they want to unravel. But that's kind of the door that's been opened here.
Yeah, and I would just, add on all sorts of provisions in the, subchapter K and the pass through
Yeah.
regime. So, all right, so we've got. I think we've set the stage. We've really given the listeners what's at stake here. So, you mentioned multiple amicus briefs have been filed. My last count was 28, but it sounded like a few more came in, and
Two
and
more
more
last
to
month.
come.
So, yeah.
Yeah, yeah. And so NTUF submitted a brief, and really we want to get into your brief because I think you all do a really nice job of laying out a path that maybe uh, is less scary, and it isn't going to be the end of the tax code as we know it. So tell us about that, and and wherever you'd like to begin with that discussion.
Well, I can begin with that it was a hard brief for us to do because I like writing briefs that say the taxpayer is 100% right. Um, and we just couldn't say that in this case. I mean, we still say the taxpayer, ultimately should prevail, but in a way that doesn't um, go beyond what really needs to be done to provide justice in this one case. So we actually filed the brief in support of neither party. Normally, briefs are in support of
Right.
one side or the other. So this is it's not often used at the Supreme Court, but it is a procedure that they have. They really discourage it through the rules because they basically you get the worst deadline out of anybody filing a brief. So I had to file our brief almost among the very first of the briefs that were filed, but that's what we did, and it ended up being in support of neither party. And the reason we did it is because we think the Ninth Circuit certainly got it wrong when they said that the federal government can basically do whatever it wants without any constitutional restrictions. And so we explain why that's wrong. Hopefully, that doesn't need much explanation about why that's wrong. And
Mm-hmm.
then um, walking through why this tax is constitutional. Maybe there's an issue as applied to these particular taxpayers as individuals with very odd circumstances,
Mm-hmm.
and that if you're going to rule, make sure you do it this way. And we kind of lay out some options for the justices, which we really drew from a lot of very thoughtful pieces that have been written on this and other cases in recent years. So, kind of the broad strokes that we give in the brief is reverse the Ninth Circuit, vacate that case. Um, don't uphold a wealth tax. Don't do that. And
Right,
then
right.
but also don't, if you're going to rule for the Moors, do it in a narrow way that doesn't have unintended consequences.
And so, is there a way that you address the realization issue that you know will help the court down that path?
Yeah, well, I mean, we give a bit of the history on it, and somebody mentioned recently that this particular Supreme Court really likes being historians,
Yes.
um,
Mm-hmm.
and so the big question will be, what did these terms mean when they were first enacted? So what did the drafters of the 16th Amendment, when they were writing it in 1909, 1910, 1913, what did they mean by the word income? So a lot of the briefs are quoting very old Webster's dictionaries and contemporary newspaper articles and speeches by politicians, because they're trying to understand, all right, what did they mean by income? And what, I didn't do any of that research. I'm not a historian, but I did read it all. And um, apparently the word income comes from the phrase to come in. It's not very elaborate definition. So this idea that it's not just a paper change in wealth; it's actually something that you receive,
Right.
and that has translated over into this concept of realization, which, for good or for bad, and people argue both ways, the Supreme Court decided was a constitutional requirement in a 1920 case called
Mm-hmm.
Eisner v. Macomber.
Yeah.
And there's a lot of people who are arguing, oh, that case was a bad one or a good one, and so maybe that'll come up of like, well, this 100-year-old case, are we going to keep it or are we going to reverse it? But um, they said for it to be income, there has to be realization. So do they find a way to square what happened here with that, or do they overrule that, or do they go in a different direction? And a problem here is that you and I are tax experts. I'm sure a lot of the people listening spend a lot of time thinking about tax. The Supreme Court is not.
Yeah.
Um, don't get me wrong, they're all very smart people and they all have very
Yes.
smart clerks and they're very thoughtful and they're going to read everything and do their best to understand it, but they do not live it and breathe it the way
Mm-hmm.
we do. Justice Ginsburg, when she was alive, her husband was a tax
Yes. Mm-hmm. Mm-hmm.
a practitioner, maybe a professor. I forget what precisely his job was, but um, she always ended up writing the tax cases, which was interesting.
Ah, okay, okay.
Because she herself was not a tax expert, although I imagine being married to one probably you pick up a few things.
Right.
Um,
Rubs off.
yeah, but since she's no longer on the court, we don't really have that type of person on
Mm-hmm.
the court. So I mean, I honestly sent our brief to a family member who doesn't follow any of this stuff, and I was like, mark the places where I lose you, because I
Yeah.
really wanted
Yeah.
it to be understandable by a layperson, which I hope it is.
Well, this is definitely one that a lot of folks are watching. I know we're both at the cost annual meeting this week, and there was a discussion on this case and just general chit chat about it. So, Joe, one last question on the case. Oral arguments will be on the 5th of December. Maybe, a Wayfair 2.0 party at the steps of the Supreme Court. So we'll see. I know that was also part of the chatter of, are people going to go to the argument?
Yeah.
Do you think that the court really knew what it was doing or getting itself into when it took this case? I kind of feel like, you know, I don't think this is a secret. The court is fairly political at this point, and we're in a bit of an interesting time. But I can't imagine they really knew what they were potentially getting themselves into when they took the case. And so it's one of the. I mean, let's think about going back to Wayfair. We all kind of thought, well, they took the case because they wanted to do something about Quill. I, I can't imagine they want to blow up the whole tax code. That's their point. I could see a version of they're not super fond of the Ninth Circuit, and this was kind of a out there decision by the Ninth Circuit, so maybe they wanted to rein them in, but this could have some real broad implications.
Yeah, I've been asking a lot of people on this, on their insights, because this, I'm guessing the plaintiffs, the firm representing the taxpayers, um, maybe they expected the court to take the case, or at least hoped that they would take the case, but everybody else seemed surprised, myself included, because the Supreme Court is asked to hear something like 6 or 7 or 8,000 cases a year, and they take about 60 or 70 or 80,
Mm-hmm. Mm-hmm.
which is, sorry, I'm not a lawyer and I can't even do that math in my head. That's either 1%
It's
or
like
1/10.
yeah, it's like a
Yeah.
1%. Yep.
So, already the odds are against you just by appealing at all. But they agreed to hear it. And the best explanation, the best guess, because we're all guessing, we don't know why.
Mm-hmm. Yep.
The Supreme Court took the only people who know that are the justices themselves. But our best guess that I've heard is, Ninth Circuit ruled against the taxpayer, strike one.
Mm-hmm.
Supreme Court doesn't really like the Ninth Circuit, thinks it gets it wrong a lot.
Yep.
Not wrong, and they're not wrong about that assessment, I must add. And then, sorry, I know you live in the Ninth Circuit, Nikki. And then there was a very vociferous dissent in the Ninth Circuit opinion by all of the conservative justices on that panel. So, these are their buddies, these are their
Mm-hmm.
simpaticos,
Yeah.
um, and then so it gets to them, and maybe that's all they know about it. And the facts as presented in the petition didn't exactly. I'm going to put it this way: they did not exactly tell the whole story, which is true of any appeal. You're not
Right.
any appeal. You're going to frame the case in the way that you think wins the case for you.
Right.
Um,
Right.
so, there have been some articles recently about, like, well, there's this fact that wasn't brought up until now, or there's this other interesting tidbit that wasn't brought up until now that maybe or maybe not is relevant to what the court should decide in this case. So, maybe the plaintiffs are the dogs that caught the car here. I don't know, but they're going to the Supreme Court, so what do I know? We'll see what the justices do on it. They know they have the case. Some senators wrote to Justice Alito and told him he should recuse himself. This is just kind of an interesting side note in
Mm-hmm.
the case. And
Mm-hmm.
Justice Alito wrote a 4-page public memo, published it to the Supreme Court website, saying he's not going to recuse himself in the case. So, it's not like it's escaped their attention that they've accepted this case. So we'll see what happens with it.
Yeah, and I'm sure as the amicus briefs come in, they must realize more and more what that how many people are really watching this case. So we will wait and see. Well, Joe, thank you so much for this discussion. I think this is really helpful for the listeners and to kind of set the stage with this case. And it's going to be fascinating to see, what happens next year when they rule in the case. So, but I can't let you go without a surprise non-tax question.
Okay.
And as I mentioned, Joe and I are both in sunny Las Vegas. It's very warm here, and we're
Cold in the rooms, I have to say, in the
yes,
conference.
yes,
They've
hard
got it about
dressing.
Antarctica temperatures in the air conditioning here. So.
Yes. But so we're in Las Vegas for the cost conference. I'm going to ask you a Vegas question for this
Okay.
one. So, to the extent you can talk about it on a public podcast, what is your favorite thing to do in Vegas? And I'll go first because that's how this works. So, my favorite thing to do in Vegas is we often come here to eat, and so we just try to get to as many of the good restaurants as we can. One of our favorites is Best Friend, which is in the Park MGM. Unfortunately, we could not get in this trip. I would highly recommend it to anybody, but there's a ton of good food here. So you don't have to come to Vegas to gamble. If you don't want to, you can just come and eat. So, what's your favorite thing?
Well, I'm going to do food too. I do like blackjack, but I've promised my husband not to do it this trip. But I do love food too, and especially like Italian food. And GeTtin's restaurant is over in the Cromwell, just actually across the street from us, tempting
Okay.
me. And actually, it. I'm not exaggerating when I say I think that's the best Italian food on the planet there. So
Oh,
I love
okay.
going there.
All right. Well, you've given me another one to add to the
Yeah.
list. So, are you going anywhere good tonight? We're going to Spago.
Spaga's pretty good. I don't think so tonight. I think I've got a night of calls that's not very exciting. So
All
probably
right.
room service for me.
All right. Well, maybe you can jump across the street if possible. So,
Right.
well, thank you again, Joe. Super great brief. Congratulations on all the great, amazing work you all do. And we will definitely be catching up again soon. Thank you to our listeners for tuning in to this episode. Information for Joe and I will be in the show notes. If you have any questions or comments, please leave us feedback. And I will be with you again on the next episode of Gettin' Salty.
This podcast episode reflects the opinions of the hosts and guests and not